The U.S. Constitution limits the government or those acting on its behalf rather than private individuals or entities. Therefore, to assert a constitutional claim, the concept of state action requires that the alleged deprivation of rights must be the result of some governmental entity's action rather than the action of a private entity. However, the status of the entity is not always easily determined. The U.S. Constitution empowers Congress to enact legislation in a variety of subject areas, such as copyrights, patents, trade and commerce, taxation, securities regulation, education, and civil rights. Congressionally enacted legislation reflects societal interest regarding future conduct about a variety of issues such as discrimination in business practices, sexual harassment or gender equity, sports betting, daily fantasy sports, false or deceptive advertising, and labor practices. In addition, many federal agencies are responsible for enforcing and implementing federal statutes. For example, the U.S. Department of Education enforces Title IX, which prohibits gender discrimination in educational programs. The DOE investigates numerous allegations of gender discrimination each year that are related to college athletics. As will be discussed later in this section, sexual harassment is a form of gender discrimination and is prohibited under Title IX. Another example of federal agency enforcement is the Federal Trade Commission, or FTC. The FTC enforces laws that prohibit false or deceptive advertising. These agencies' responsibilities can also include adopting guidelines to aid organizations and persons subject to the law in question. For example, the FTC has adopted social media endorsement guidelines to help celebrities who endorse products understand their responsibilities to consumers when they tweet or post comments about the products they endorse. Title IX, enacted in 1972, prohibits discrimination based on gender in any federally funded education program or activity. Because almost all colleges and universities receive federal funds either directly or indirectly, they are subject to Title IX. Since 1972, Title IX compliance became synonymous with gender equity in athletics due to the continuing challenges faced by athletic programs to ensure equal opportunities in everything from financial aid to participation numbers to facilities and support services. For many years, compliance with Title IX in athletics was primarily evaluated in three areas and involved several specific federal regulations adopted and enforced by the DOE. The first area looks at the school's distribution of financial aid among its women's and men's athletic teams. The second area evaluates other benefits, opportunities, and treatments with men's and women's sports programs and a variety of support service areas such as travel and per diem, locker rooms, housing, and publicity. The third area examines whether the interests and abilities of the underrepresented group of women have been accommodated, or men. Evaluation of this third compliance area uses a three-prong test, but it is the first prong that has prompted numerous legal challenges. The prong permits compliance in this area if a university provides participation opportunities for females in proportion to the percentage of females in the university's undergraduate student population. For example, if the population of the full-time undergraduate student body at a state university is 53% female, the percentage of female student athletes should also be 53%. The proportionality prong has been criticized as an impermissible quota. But the courts have consistently upheld the test because there are two other prongs under which a university may demonstrate compliance. Certainly, there is still controversy regarding how to ensure that equal opportunity exists in athletics, but more recently, Title IX concerns in college athletics often relates to sexual harassment and sexual violence on college campuses. The legislature of each state is responsible for enacting laws to govern its citizens in matters where federal legislation is silent. Each state has a constitution that sets forth the rights of its citizens and the limitations of the state government. The state's constitution is the highest legal authority in the state. Its statutes or written laws must always be consistent with the United States Constitution. If they are not, The courts will deem the statutes as invalid. State statutes may be more restrictive than the corresponding federal laws on point, but they may not be less restrictive. Think of the federal laws as a floor, not a ceiling. The two areas of law that are based solely on state law are torts and contracts. Issues concerning these two specific areas of law will never be federal issues. As you'll read in the next section, a tort is a civil wrong, a wrong that was done to one person or persons by another person or organization. The injured party will use tort law to seek a remedy to compensate them for their injury or loss, or to correct the wrongdoing to the best extent possible. Similarly, contract law is the law that governs obligations or reciprocal promises by or between parties who entered into an agreement, and it provides a remedy for a party whose contract is breached or not performed properly. Tort law cases can range from those involving product liability, such as head injury because of a faulty helmet, to those associated with medical malpractice or a misdiagnosis of a career-threatening injury. A tort is a civil wrong or injury for which the law permits a recovery. Typically, a wrong or injury is either a negligent act or an intentional act by one person to another person or his or her property. Tort law focuses on whether a person or persons failed to perform appropriately based on his or her or their relationship with the injured plaintiff. Compensatory or punitive damages, or both, can provide a remedy for the wrong. Compensatory damages can be monetary damages for medical bills, lost days of work, payment for hired hands, lost earning potential, and pain and suffering. Punitive damages can impose additional monetary damages on defendants that serve to punish them for their wrongdoing and make an example of their conduct, so others do not engage in similar acts. Punitive damages are much less common and often greatly exceed the actual costs of the injury. Punitive damages are generally available only for intentional torts. Negligence is a tort that is classified as unintentional. Even if a person does not intend to cause harm, they can still be held responsible. Hence, the defense of "I didn't mean to do it" is unimportant in negligence. The law requires that where a duty is owed, one must act in a reasonable and prudent way, which means sound judgment and care and thought for the future must be shown. Intentional torts, on the other hand, are wrongs that result from purposeful conduct. These claims may include defamation, invasion of privacy, assault, and battery. The next two sections will provide you with an understanding of the legal aspects of negligence and intentional torts and their application to sport. Negligence represents the failure to act as another reasonable, prudent person would have acted in a like or similar circumstance. To prove negligence, a plaintiff must prove the following four elements: duty, breach of duty, proximate cause, and an injury. The duty can be based on the relationship with the plaintiff, a coach and student athlete, the teacher and student, manager of a sport facility, and spectator. Voluntary assumption of a duty, such as volunteer coach who agrees to assist student athletes with their college application materials, or duty imposed by statute, such as a state law that requires lifeguards at all public swimming pools. Breach of duty, the second element, represents a failure to act as a reasonably prudent person would have acted in the same or similar situation. Typically, liability occurs when an injury is foreseeable by another reasonably prudent professional, or the defendant's actions reflect a disregard for the relevant professional standards. Proximate cause relates to the linkage between the defendant's failure to adhere to the standard of care, the breach of duty, and the actual injury suffered. This means that although the defendant may be negligent, the injury may have resulted from some other intervening act. When dealing with a negligence case involving an injury resulting from the land or the facility, the status of the injured party changes the duty owed from the responsible, reasonable, and prudent person standard, as we learned, to one of the following. For invitees, the landowner's duty is to maintain the premises in a reasonably safe manner under the circumstances. For licensees, the landowner's duty is to warn the licensee of known risks. And for trespassers, the landowner's duty is to refrain from willful and wanton misconduct. In other words, not setting booby traps to intentionally cause harm to the trespasser. One important thing to note regarding the duty owed to a licensee is the phrase known risks. And the law, knowledge means that one knew or should have known. There are two types of knowledge, actual and constructive. Actual knowledge means the person literally knew of the risk that existed. Constructive knowledge means the person should have known about the risk if he or she had used ordinary intelligence or had been reasonable in the inspection of the premises. An analysis of causation and damages will remain the same. Remember, all four elements of negligence must be present to find the defendant liable. Tort claims may also result from intentional rather than negligent conduct. A number of intentional courts provide a plaintiff with a legitimate cause of action. Intentional courts include invasion of privacy, defamation, assault, and battery. A state law right that is also highly relevant in the sport industry is the right of publicity. Publicity rights evolved from invasion of privacy rights but are now recognized by many states by statute or common law as independent rights. Right of publicity claims are similar to invasion of privacy claims, but with a twist. Publicity rights protect the commercial value of a person's name or likeness from intrusion or misappropriation. The tort of defamation strives to protect a person's right to his or her reputation, pride, and integrity. A successful defamation claim is difficult to prove and can require years to litigate. Agreement between parties to do or not to do a particular act. For most people, a contract is a written document in the sports industry. We often recognize common contracts such as professional athletes, multi-million-dollar player service contracts with professional teams, such as Kevin Durant's 2016 signing with the NBA's Golden State Warriors for 2 years and $54 million. The law of contracts in an ordinary legal sense is based on agreements. It provides an avenue for two or more persons to enter into an agreement, although through voluntary promises that the law enforces. Furthermore, it provides a legal mechanism for protecting and enforcing the expectations of the parties involved, the people who are part of the bargain for agreement. To enforce agreements under contract law, courts look to common legal principles under state laws that provide roadmaps and for understanding what makes a legal binding contract and the legal effects that may occur when a party does not perform their contractual obligations. To create a contract, the agreement must consist of three basic legal elements associated with contract law. Number one, a valid offer. Two, a manifestation of acceptance of that offer. And three, an exchange of value gained through the contract known as consideration. An offer is considered valid when one party, the offeror, the person making the offer, communicates a complete proposal, the offer to the offeree, the person to whom the offer is made, with a present intention to enter into the contract. The offeree must actually receive the offer, and the essential terms of the agreement must be defined enough to allow the receiving party to accept and perform the requirements of the contract. For the offer to be valid, it is important that the following terms are clearly defined: the parties of the agreement, the price to be paid, the time and method of payment, and the subject matter of the offer. The acceptance is a clear and voluntary communication to the offerer that you agree to the terms of the agreement. Proof of acceptance usually takes the form of a promise or action. For example, an acceptance of an offer to sell your baseball cap for $30 could entail the offeree saying, "Yes, I'll buy your cap," or the offeree's act of handing you the purchase price of $30 for the cap. Consideration refers to a bargain for exchange. This exchange can include a benefit or detriment, promise not to do something. A bargain for exchange is present in the following examples: I'll pay you $2,000 in exchange for Super Bowl tickets. Or I'll pay you $50 for your signed Mike Trout baseball card. A promise to give you a hitting lesson in exchange for $50. and a promise to not sue your company for trademark infringement in exchange for your promise to no longer use the trademark. Many sport organizations use contracts and contract law daily. Waivers and releases, all called exculpatory agreements in contract law, are examples of common contracts used in the sport industry. These types of agreements are used to excuse an organization for its own acts of negligence. For example, health clubs typically require members to sign a waiver before they use the facilities, programs, and equipment. The signed waiver excuses the organization from ordinary negligence liability, even if an employee of the health club is responsible for negligence that results in harm to the user. The validity of exculpatory agreements will be weighed by courts in light of surrounding circumstances and applicable state law. Waivers and releases do not offer foolproof protection for the organizations using them. Courts will look at whether the agreement was clear, verify that both parties are aware, and show intent of release, and confirm that the negligent actions did not rise to the level of willful or gross negligence. Exculpatory agreements will continue to be used heavily in the sport industry with little risk for the sport organization seeking to avoid liability. The daily decisions of sport managers profoundly influence employee and customer recruitment and retention, as well as organizational solvency. Effective and efficient sport management entities require managers who are cognizant of how their actions influence others, further the law, such as constitutions and common law. As a dynamic environment that constantly changes and requires managers to adapt and respond, failure to comply with the law can bring individual and organizational liability. Liability risks increases when professionals fail to act as other responsible or reasonable professionals would act in similar situations. Office conduct and related policy issues such as maintenance of personnel files, communication with the media, and inspection of employee email communication can subject an organization to invasion of privacy or defamation litigation. Contract negotiation is becoming a vital skill for sport managers as the sport industry continues to expand. Compensation for an average NCAA Division I coach is often in the millions of dollars and flows from a variety of sources such as salary, media shows, perks, endorsements, licensing opportunities, sport camps, personal appearances, and performance bonuses, all of which must be provided for in a clear and enforceable contractual agreement. In addition, college apparel contracts are escalating in value every year, and three major brands, Nike, Adidas, and Under Armour, are actively competing for the top-ranked athletic programs. UCLA switched to Under Armour from Adidas resulted in a contract worth $280 million over 12 years. Sport managers in leadership positions today must thoroughly understand contract law and be prepared to make challenging decisions regarding the retention and hiring of coaches and administrators, and also be able to be innovators and must also be innovators when negotiating apparel and other sponsorship agreements to maximize the value of these relationships. And lastly, concussion litigation will continue to be a growing concern for sport managers from professional to youth sport environments. One of the major legal issues of the sport industry revolves around player safety and specifically concussions. From the most prominent league in sports, the NFL, to an amateur level of Pop Warner, player safety is at the forefront of the industry. Recent news media, literature, and even film, Concussion starring Will Smith, have promulgated the legal issues inherent in sport safety programs and safety protocols. Publicity has more recently named football specifically as a sport that is unsafe. Sport law and ethics often intersect in a variety of ways, ranging from constitutional and contract law to intellectual property and agency law. The first ethical dilemma involves concerns that may arise between an agent and his client. One example is if an NFL player is charged with driving under the influence, but fails to inform the league. The incident reporting clause of the NFL personal conduct policy requires employees of the NFL to inform the league of violations. If the player, the employee, which is the employee, fails to report the incident and the league finds out, the player's punishment could be harsher. DUIs fall under the NFL's substance abuse policy, which states that a player will be fined 1 game check at minimum, and subsequent violations could result in suspension. The agent has an ethical obligation to advise his client to abide by these rules regardless of the lost money. If a client refuses to take an agent's advice, should the agent fire the client? If the agent is also an attorney, as many are, the agent cannot legally break client confidentiality and inform the league. The personal relationship between a client and agent is vital. It is the sake of his reputation and longevity in the field, and he should encourage his client to do the same. The second ethical dilemma is a result of the successful lawsuit of a former UCLA basketball standout, Ed Albanian, against the NCAA. This lawsuit challenged the NCAA's restrictions on student-athlete compensation for use of the athletes' names and images on memorabilia, video games, live broadcasts, and other means, which generate billions of dollars. After the court in the Albanian case held that the NCAA rules restricting universities from compensating athletes violated federal antitrust laws, many universities started to provide stipends for student athletes. The stipend amounts vary considerably from one university to another. In addition, many athletic programs have been unable to offer any stipend due to limited budgets and rising operating costs for athletics. Athletic administrators have to evaluate how best to navigate these budget challenges in a fair and ethical manner. They may feel that to be competitive, they must provide the maximum stipend amount. However, if they do not have sufficient funds to support that expense, it is quite likely the university will have to subsidize these costs through additional student fees or redirecting university resources to athletics that were intended to support academic initiative. Here are a few questions that could be on the test. What are the 4 elements of negligence that the plaintiff must successfully prove? I'll just say that definitely that is one that will be on the test. Under Title IX, what are the primary responsibilities of colleges and universities to address issues of sexual violence on college campuses? And what are the 3 elements of a valid contract? Be able to explain each element. This chapter discusses how to identify legal issues that affect sport management operations and introduces many basic legal concepts that affect sport managers. It also identifies and explains many ways legal issues influence the sport industry and emphasizes how important it is for sport managers to make effective decisions when confronting legal issues. To recognize and respond to legal issues successfully, effective sport managers must engage in critical thinking and prudent problem solving. An effective sport manager must have a basic familiarity with the legal system, sources of law and the court system, and a working understanding of myriad legal topics and issues such as premise liability, defamation, sexual harassment and sexual violence policies, social media policies, and federal labor laws. Moreover, because employment, apparel, and sponsorship contracts are an integral part of professional sport and college athletics, sport managers and athletic administrators must be knowledgeable of and adept at working with the critical components of these agreements. And lastly, people are increasingly looking to the U.S. Constitution for protection and asserting fundamental rights and issues related to sport. This chapter introduces these and other legal issues that affect sport managers, sporting events, and sport organizations. Thank you for joining me today. I look forward to talking with you again. Have a great day.